Good morning. My name is John Zervopoulos. I'm a psychologist and a lawyer here in Dallas. And we're very pleased to be part of this panel this morning on the Confidentiality Maze and student information. I want to thank the Dallas Bar as well as the Caruth Institute for Children's Rights as a part of the SMU Dedman School of Law. Special thanks also to Diane Samosky. She's the director and supervising attorney of the Caruth Child Advocacy Clinic, and she has done an incredible job in pulling this together, organizing us and keeping us all on task. So Confidentiality Maze and student information. We've all become privacy conscious these days, aware of the possibility that others can access our personal information without our knowledge or permission. The same awareness impacts personal information of students as well. Now, over the last 25 years, several federal and state laws and sets of regulations have been instituted to address how to manage students' personal information. I emphasize several because that's where the rub is. It can get complicated to navigate the maze. You'd think that mastering one set of regulations can be a challenge. Mix in 2 or 3 other sets, and we can all get quickly turned inside out. But if you know a few key concepts, you'll be able to make some sense of the issues that may arise when dealing with confidentiality and managing students' personal information. That's our goal for you in the short time that we have today. Now, our format is 2 parts. The first, in this time before lunch, we'll introduce 3 key aspects of confidentiality that may play in situations involving students. The second part is after lunch, where we'll present a couple of scenarios based on the first part we'll ask your participation in thinking through how to navigate the issues raised in those scenarios. So let's get on with our first part. Denise Brady will begin with a discussion about the law related to confidentiality and child welfare's involvement in a student's life. Denise is a senior policy attorney at the Texas Department of Family and Protective Services in Austin. Then Montgomery Meitler will talk a bit about FERPA. All these acronyms are kind of crazy and a little bit weird too. The Family Education Rights and Privacy Act, which applies to the confidentiality of students' records. Montgomery Meitler is an attorney, senior counselor, and confidentiality officer at the Texas Education Agency in Austin. And finally, I'll highlight some key privacy concepts in Hipaa. So with that, I will give the baton to Denise.
Good morning. Thank you, John. So we were discussing amongst ourselves that we'd be interested to find out who you all are, because I couldn't quite tell from the prior session what people's backgrounds were. How many folks here are with CASA? Oh my goodness, okay, most. So how many folks are attorneys that are appointed as a guardian ad litem? Couple, all right. School people, educators. Okay, a mixture. What have I forgotten? What else?
Child placing agency.
Child placing agency, CPS. Right, CPS, of course. My home, I'm sorry. I just automatically know who you are. Okay, great. Well, so you're going to maybe learn something new. Maybe this is going to be review, but we'll just try to cover the basics like John was saying. If you can sort of get the framework for it, then even if you don't have all the details and you have a specific situation, you can kind of go back to the framework. All right. So again, I'm representing the children who are in DFPS conservatorship or custody, temporary managing conservatorship, different terms you might hear, permanent managing conservatorship, foster care. If it's a child who's not in the agency's conservatorship, these laws don't all apply. So that's kind of what we're starting with, that this is children who are in foster care, conservatorship. So the relevant laws are CAPTA, Title 4E of the Social Security Act. Those are the 2 big federal laws that give us funding to carry out child welfare, and they both contain confidentiality provisions. Then in terms of state law, there's the Texas Family Code and the Texas Human Resources Code. And those also have confidentiality provisions regarding children in care. And then Texas Administrative Code, those are our rules, and those have further provisions regarding confidentiality. Putting those all together, the big picture is that when necessary to meet a child's needs, DFPS staff and providers, so CPAs, may share child information with anyone who's responsible for any of those bulleted items. The child's protection, diagnosis, so that's going to mean healthcare providers, child's care, treatment, supervision, or education. So it's a case-by-case decision of when those items need to be shared. It's on a need-to-know basis. And our general philosophy is share the minimum amount with the minimum number of people who need to know that information. So when you're talking, we'll talk more in a second, but when you're talking about the school setting, it might be that the school counselor needs to know the child is in foster care, but not every one of the teachers. It's just going to be a case-by-case determination. Who needs the information? School personnel are going to need some of the information. Healthcare providers will need certain information about the child. The caregivers, whether it's a foster caregiver or a relative caregiver, or you might hear the term fictive kin, and that's a person who's in the role of a relative who's taking care of the child that's in foster care. Residential treatment providers, CASAs, attorneys and guardians ad litem will need certain information. The biological or the legal parent, even though we have conservatorship, they have certain rights to information about their child unless we've terminated their parental rights, of course. And then prospective adoptive parents. Before a parent is going to adopt a child, they have a right to know all the child's medical condition, all the history we possibly have about the child, we share with prospective adoptive parents so they can make an informed decision about adoption. And then there's others. So I thought, and this is going to be a really quick overview, to talk about who can share information. I want to just make sure y'all understand the role of making education decisions for children in foster care. So as we talked about, when we're named as the child's managing conservator by the court, so we have the authority to make the big decisions. And when I say we, I mean the Department of Family and Protective Services, or some of that might be delegated to a child placing agency. And we're the ones who are deciding the child's placement. And so part of that is going to be the decision of what school should the child go to. The child has the legal right to stay in the school they were in before their placement changed, but we have to make a determination of what's in the best interest. And it might be that the best interest is to change the school because the foster parent lives so far away from the original school that we don't want them driving an hour each way. But that's a decision the DFPS makes. However, we need to delegate the day-to-day education decisions to the child's caregiver, because some of that stuff just has to be the person who's at home with the child. And the child's coming home with homework, we need to be designating a day-to-day decision maker. So that's going to be the caregiver or other person who interacts with the child regularly. So if the child's at a residential facility, they might have someone designated to be that child's link and liaison to the education realm. Special education decision making is a whole different set of laws, and the previous panel made some reference to it, and I'll talk briefly about that in this context. So, like I said, education decision maker makes it day-to-day education decisions. Can the child go on a field trip? Can the child go to the fall harvest dance? And the law requires us to name this person. So we use a form, 2085E, and on that form, and I have a slide of it coming up, we name who is the education decision maker that we've designated to be that day-to-day person to make education decisions. And the caseworker's name is on there, and contact information. If the child has a surrogate parent for special education purposes, that's on that form. And then by law, we have to file that form, or we have to tell the court who we've named and give that form to the school. So when we hear from schools that they don't know a child is in foster care, we're always surprised, because according to the law and our policies, you're supposed to be getting this form. Here's a screenshot of it. I know that's kind of crazy, you can't see it, and it's about, is it 4 pages long, Carol? Right? It's 4 pages long. So it's got all the important information about the child and what kinds of decisions can be made by whom. We have another form that is the Form 2085, and that's the form that we give to the child's caregiver that just says they have the authority to basically have possession of that child. So that's a form that foster parents have or the residential provider has. They're also supposed to give that to the school when they're enrolling the child. And that way the school has noticed this is a child who's in conservatorship. This triggers PEEMS. Schools now are tracking children in foster care and PEEMS. And so receiving these forms at enrollment is what triggers, hopefully, if it's working, the PEEMS coding for the child. And then it also triggers the child is automatically eligible for school lunches, school breakfasts, the nutrition program. So getting this form is the flag for the school that, oh, this child is in foster care and they're eligible. And here's the important part in terms of confidentiality. That person, anyone who's holding one of those forms, has to have all the information about that child in order to make those decisions for that child. So for IDEA, like I said, the previous panel talked a little bit about this. Who is a parent for special education decisions can be slightly different from who is the education decision maker for a child in foster care. For the regular decisions, it can be a staff person. It can be a caseworker. If you see the definitions of parent under IDEA, it can't be the state. See the third bullet? First one is the child's parent. Second one is a foster parent. Third, the child's legal guardian, but not the state if the child is a, quote, ward of the state. So when it comes to special education decisions, it's generally going to be the foster parent, relative caregiver. If the child's in a residential facility and doesn't have one of those caregivers, that's when we're going to see a surrogate parent being appointed by the school. And then they'll be the special education representative at the ARD meetings that the prior group talked about. So we have this great booklet, and I didn't have room in my suitcase to bring enough for everyone, but the Texas Supreme Court Children's Commission, in conjunction with TEA, Montgomery helped with this, and DFPS, has put out this really, I think it's really good, I helped write it, so of course, it's a whole guide about sharing information in the school system, and we can make sure that I give the link to Diane and folks, and then you guys can get the link to it. So basically, I'm doing a little cliff notes of what's in this for the next couple of slides. Information that is generally appropriate for CPS to share with school personnel is these forms I talked about that indicate the child's in foster care and the person holding the form has the right to information about the child, the CPS caseworker and contact information, the fact that the student is in foster care, obviously, and then important documents that are needed for enrollment. So if a foster parent is enrolling the child and you need the birth certificate and immunization documentation, obviously all of that we can share. Okay, this category is the generally okay to share. Evaluations, hearing and vision evaluations, those might be relevant for special education purposes. Medications that the child has to receive during the school day, going to need to know about those if you're going to be in any way involved in the child, making sure the child gets them on time. If the child is eligible for Medicaid and receives special education, there's a program called SHARS, School Health and Related Services, where special ed services can be billed to Medicaid. Well, in those cases, you're going to need the child's Medicaid number. We can give that. And then information for transition planning that takes place when the child is 14. We might need to share that when it's relevant. More information that it's generally okay to share if it's relevant. Medical, disability, health information, psychological evaluations, but we generally want to redact information about the child's parents, their biological parents. That's not information that you necessarily need to know in the school context. Behavior supports that are used in the home in case those need to be carried out while in the school setting. Some juvenile justice information if the child is on probation. And now this last one is the trickiest one. Information about the impact of abuse or neglect history when it's related to school behavior. We know that the school wants this kind of information so they know how they can best help that child, but it can be a very careful balancing act regarding how much we need to be sharing about the child's history and background and abuse history. And then we have some categories that we say generally this should never be shared. Whoever reported the abuse or neglect against that child, we call that person the reporter. That is the most confidential piece of information in the entire child welfare world, is who reported it. We want that person to feel safe with that knowledge. The fact that the child was adopted, if down the road they're adopted, nobody needs to necessarily know that child's background. If alcohol or substance abuse history or treatment of the parents or even of the child is very highly protected under a whole different federal law that we're not even going to talk about today. So unless that's relevant somehow, that's not something that we need to be sharing. And then we've heard stories of where the foster family is asked for proof of their income for some reason. These children are automatically eligible for school nutrition programs, so no one should ever be needed to sharing their income with the school. That's not a necessary sharing. And if you have any questions, the room is small enough that I feel comfortable saying you can email me with questions, or we can maybe take some at the end of this overall presentation or after lunch, because I know that was super fast.
And all of these presentations will be put on our website so that you can have access to them. We'll send you a link afterwards, and definitely of this awesome book, too. Very good.
Well, while we're switching out, any quick question, clarification, something that you feel like you don't get clarified, you're just not going to understand the rest of? Yes,
This may not be the appropriate time to mention this, but I'm an advocate for an 11-year-old boy, and it seems like he's been moved twice, 2 different foster homes, and each time the foster mother had no access to this Form 2085.
The foster parent didn't have the form? That's not supposed to happen.
Their CPS caseworker would be the person that I could go to and say, where is this?
Yes.
Okay.
Yes.
All right, good morning. I'm Montgomery, Senior Counsel and Confidentiality Officer at the Texas Education Agency, and I'm going to discuss education records and the right of access to those education records. Our primary statute that's going to govern education record at what FERPA would call an SEA or an LEA, your local education agency or your state education agency, is FERPA, the Family Educational Rights and Privacy Act. And that's going to be applicable to an entity that receives funding under or an education program from the United States Department of Education. If you accept those funds, you are subject to FERPA. And FERPA is going to guide, protect the privacy interests of the information in that student's education records. So what is an education record? The definition in FERPA is incredibly broad. If it directly relates or identifies a student and it's maintained by that SEA or LEA, it is an education record protected by FERPA. There are 6 categories that FERPA expressly states are not an education record. The only one I'd really like to point out to you are law enforcement records. If your independent school district has its own police department, the records maintained by your district police department are not education records. They are law enforcement records not protected under FERPA. There might be other protections that law enforcement has in regard to your Texas Public Information Act, but for the most part, they are not education records protected under FERPA. And then I'll let John address the HIP issues when we get to those. Photos and videos, those are education records if they directly relate to a student. And through the years, we put more and more cameras in buses and in hallways at the school, and our state statute was enacted, I think, 2 sessions ago, allowing cameras in special education classrooms. So I receive a lot of questions about students depicted on videos. Again, if it's directly related to a student, it is an education record of that student. We recently, after years of asking for it, received guidance from the Family Policy Compliance Office of the United States Department of Ed, trying to help us better understand FERPA's application to videos. So in the scenario where you have students depicted in a video, the students that are maybe in the background of that video is not directly related to those students. They're just kind of background. So it is not an education record for those students. However, the 2 students at the foreground, maybe there was a fight, and all the other students gather around to watch it. Well, it's not an education record for the kids watching, but for the 2 students in the fight, that is an education record of those 2 students. Now, to the extent the school district's police department maintains a copy of that video, that is a law enforcement record. It is not protected under FERPA. However, if the school district maintains a copy of that video for disciplinary actions against those two students, that is an education record for those students protected by FERPA. So it can be held in two different places within the school district and have two different confidentiality statutes addressing it. And then as far as a parental right of access to that video, you've got two students. You've got one record that is an education record for two different sets of parents. So FERPA would, the new guidance issued from the Department of Ed would basically state, you cannot deny that parent a right of access to their child's education record, even though it might be at the expense of another parent's right of access and confidentiality to their child's education record. So the guidance that has been provided would state, both parents have the right to go view that video, but they aren't entitled to a copy of that video without written consent of the other parent. So it's a bit confusing, but after years and years of asking for guidance, we finally got it. So I'm very happy about it. I get a lot of questions about videos. Student health records, and this slide will make a lot more sense after John's presentation, student health records maintained by your SCA or your LEA, your local education agency, are not HIPAA records protected by HIPAA. They are education records protected by FERPA, and that's primarily because your local education agency is not a covered entity under HIPAA, and any health information maintained in those records are in records that are by definition education records protected by FERPA. So generally, pre-K through 12, these are going to be education records under FERPA, not HIPAA. Now, when you get up to college, things are going to flip back over to the HIPAA side, and John will address that. Okay, so who has a right of access to education records? Parents, and the parent is going to be defined as the parent, the guardian, or an individual acting as a parent, which would certainly include your CPS caseworker when the child's in the managing conservatorship of CPS. And what rights does a parent have? They have three main rights under FERPA. They have the right to inspect and review their records. They have the right to seek amendment to those records, and that does not mean you disagree with the grade your child received. That is not what can be amended. It has to be something that's legitimately incorrect in that education record. And they have the right to consent to the disclosure of those education records to a third party. The school district, generally speaking, they have the responsibility to protect the confidentiality of those records, and only a parent can permit the disclosure of those records to another individual. Now, when the student turns 18 or enrolls in post-secondary education, those parent rights transfer to the student. At that point, in accordance with FERPA, that student is called an eligible student under FERPA. And I do receive a lot of questions where you have a high school student who's also enrolled in their local community college or receiving dual credit. The guidance that the Department of Education has provided us basically states, because the child's primary enrollment is in high school, K through 12, your independent school district, for those purposes, they're not an eligible student. The rights maintain with the parents. Any questions about that? I do get a lot of questions on that one. So, access to education records. Like I said, only the parent or the eligible student has automatic access to their education records. And when a school district wants to release it to a third party, or the parent wants it released to a third party, they have to provide written consent. And FERPA is very clear as to what must be maintained in that written consent. It must state the purpose for the disclosure, the party to whom the records will be disclosed, and it needs to describe which records. They can't be very general and just say, all my kids' records. They really need to state a specific purpose. And FERPA is very clear that when you are granting access to records, you only grant what is actually necessary. It's not just an open, here's all the records. It's just what you need for what particular purpose you're seeking that access.
That should sound familiar, right? Same as the CPS.
Now, access versus copies. FERPA is a right of access statute. It is not a right to a copy. And I don't think a lot of people really understand that, but the rights under FERPA are to access and review. A copy is only required when denying access would prevent the parent's right to actually review and inspect. So if the parent does not live in that school district and the commute is too much, then a copy is going to be required. But otherwise, FERPA is an access statute. There's IDEA, which has been referenced earlier. It does provide parents a right of access or a right to a copy of the child's IEP. But for the most part, IDEA defers to FERPA for the confidentiality of those special education records. Now I'll start getting into the exceptions where parental consent is not required for a school district to release education records to a third party. FERPA was amended in 2013 to allow access to our CPS caseworkers, where CPS, generally CPS meets the definition of a parent when CPS becomes the managing custodian of the child. So they would have had that access as a parent. But to clarify things, in 2013, the statute was amended to expressly allow the child welfare agency that is legally responsible for the care and protection of that child automatic access to those child's education records. There's also another part in that amendment where FERPA requires when a school district receives a subpoena or judicial order, you're supposed to inform the parent that that order's there. You have to give them the opportunity to quash that subpoena or object to the order before that information is released. But in the Uninterrupted Scholars Act amendment, for this scenario, the school district's not required to inform the biological parent of any judicial order in this context. The other exceptions in FERPA where a school district does not need parental consent to release education records, there are several. These are just probably the ones I see most often. To other school officials within the school district, provided they have a legitimate educational interest. So just because the student is enrolled in Dallas ISD does not mean every employee in Dallas ISD gets to view the education records of that child. They have to have a legitimate educational interest. FERPA does not define what that is, but that gives you the flexibility to know that the individual who's looking at those records has to have some sort of interest in that child's education. The health and safety emergency exception, that is designed if you need to release education records or information from education records to protect the health and safety of that student or other students. And the emergency must be imminent. And I always kind of jokingly say, if you're calling my office to ask me if the emergency is imminent, it's not. The guidance on that statute is very clear. It has to be an immediate emergency to warrant disclosure of those records to first responders or whomever. Also, other school officials when the student is transferring schools. Unfortunately, a lot of our foster students have to change schools multiple times. While schools are allowed to talk to each other if the student is seeking to enroll or has enrolled in a new school. Those schools can make those transfer of records without the written consent of the parent. Which brings me to TREX, the Texas Records Exchange. It is an electronic transfer of education records between school districts. And it's in statute, the Texas Education Code. School districts are required to use it. And we encourage it simply because it does make it a lot easier. And the records are encrypted, therefore they're protected. The confidentiality can be maintained while they're transferring from one school district to the other. And statute requires you to use them. So it facilitates the process of responding to the requests. So when the student is enrolled in the new school district, that new school district sends a message to the prior school district to have those records sent over. And the receiving school district, the one who received the message to send the records, has 10 working days to get those records over. Let's see, the previous slide lists the information that our TEA student attendance accounting handbook requires to be included in that records transfer. And then the Education Code 7.010 lists additional information that must be included in that records transfer. And we always encourage registrars, if there's any information you feel is relevant to that student, it can always be downloaded as an attachment to that records transfer. We especially encourage that for special education records. So even though it's not on that list, does not mean you as a school district can't provide more information than what is legally necessary. Again, no parental consent is required. There's a FERPA exception that I addressed earlier, that if the child is seeking to enroll or has enrolled in the student, enrolled in the new school, then those two school districts can talk to each other and transfer those records. And then some other statutes that relate to education records that I just wanted to mention. IDEA, which I did earlier, it references back to FERPA as far as the protections of the student information, but it has some extended protections for parents. For example, they are allowed a copy of the child's IEP, and they're required, a school district is required to notify the parent before the destruction of any education records, special education records. Also, the Texas Public Information Act. We do receive a lot of PIA requests for education records. The PIA expressly does not require the release of information in education records under the Texas Public Information Act, except in accordance with FERPA. So again, it defers back to FERPA. And then Education Code 26.005 lists records that parents have an absolute right of access to. And again, you as a school district can always go beyond that, but the state has a list of records that they feel a parent always has a right of access to. So that's kind of a general overview of education records. And any questions? Yes, ma'am.
Hi, I'm a school counselor, and occasionally we will have CPS workers come to school to speak to me about attendance or grading or behavior. And the student is not in foster care, they're still with their parent, they just have an active CPS investigation out. And sometimes I'm like, what can I say? What can I say?
Well, I think ultimately the information you can provide, if it's information in the child's education record, you have to ensure that person is, if it's a CPS caseworker, that child's in the managing conservatorship of CPS. Otherwise, those rights are with the parent, biological parent. So you can only, in that scenario, would provide additional information if you have written parental consent to do that.
Except I think, Montgomery, it seems like you said we were conducting an investigation. So during a child abuse investigation, isn't there?
Now, for a child abuse investigation, there I think you're going to get into the health and safety concern of the child, and if that's generally how we're going to release that in accordance with federal guidance with COPTA.
Captain.
CAPTA, the federal guidance we receive with CAPTA and FERPA pretty much allows, they're like the intent of those two statutes working together in the course of a CPS investigation would be to allow access in the course of that investigation.
Or an active investigation.
Correct.
Right. So there is another category of children, families that are in our family-based safety services programs, and they are not children that we have conservatorship of, yet the investigation might not be active, so it's kind of a middle land. And I'm not the FERPA expert, but it does seem to me that under FERPA, those rights are still with the parent and not the CPS caseworker.
I will add, though, what I'm talking about is information in education records. If you had information that is not maintained in the child's education record, that it's not going to be FERPA protected. I realize that's a, kind of a gray area, but.
Attendance, any behavior referrals, and that's education.
Right.
Child that's not in our conservatorship. Carol, does that sound right? I'm referring to here my colleague, Carol Self, is the Director of Permanency for DFPS, and she's going to be up here with us after lunch, and she's really an expert out in the real world, so I'm wondering if she had a difference.
I mean, for a family-based case, the family-based safety services case, which is that period where we're offering services to the family, but we don't have legal conservatorship of the child. I think questions regarding attendance would be pertinent for us as an agency as we're evaluating and offering services to the family. I think the other thing is information that we would probably get from the parent and get
parental consent to get that information. Oftentimes, it's standard that our staff will get a basically a waiver, a release of information for anybody that we're working with when we're in family-based, but It really depends on what's going on with that particular case.
There's going to be more opportunity to ask questions in the next session. I'm so sorry, and we keep shutting you down. But let's go through the HIPAA, and then maybe you could actually ask your question.
Oh, I thought you were just showing us other people had questions. You've had a question too. I'm sorry.
Okay, don't you all feel like we're part of an esoteric club knowing all these acronyms and so forth? So we've talked about confidentiality in the context of child welfare's involvement in the student's life, and we've talked about FERPA, which addresses confidentiality of a student in public school. Let's touch now on confidentiality and HIPAA. Now, although HIPAA issues don't rise often in public school contexts, they do arise. So let's take a few minutes to highlight some key HIPAA concepts and definitions that you can be aware of when you are faced with distinguishing the application of HIPAA versus FERPA. Yeah, I've got it. So let's start from the start. I'm reading here from the Mental Health Records chapter of the Texas Health and Safety Code. Quote, communication between a patient and a professional and records of the identity, diagnosis, evaluation, or treatment of a patient that are created or maintained by a professional are confidential. What about confidentiality in children's records? The mental health professional may disclose confidential information to a parent if the patient is a minor. But note that the confidentiality of mental health records is not absolute. The exceptions to confidentiality are determined by the ethics codes of mental health professionals and by state and federal laws and regulations. So you'd like to review confidential counseling or assessment records of a child that were developed with a private therapist or psychologist who is not working on behalf of the school district or the school district. How do you access those records? And HIPAA generally sets those rules. HIPAA is the Health Insurance Portability and Accountability Act. It sets the standards for protection and sharing of individually identifiable health information that may turn into protected health information. And just like acronyms, there are terms here that may be a little bit strange, but hopefully within a few minutes you'll be able to understand the definitions and start integrating these in your thinking about these. Now, I'm sure you've realized how HIPAA has become part of the fabric of our lives. If you go to a pharmacist and CVS, for example, you see a sign that says, step back while someone else is picking up their prescription, because they don't want you hearing the conversation between the person picking up the prescription and the pharmacist, or to see anything on the computer, all right? And everyone in this room has signed countless numbers of forms that authorize the release of your medical records. But what about children? Parents or guardians of minors generally act as personal representatives of children, except in certain circumstances. First, when the minor is the one who consents to care and the consent of the parent is not required under state or other applicable law. And that's pretty limited here in Texas. When the minor obtains care at the direction of a court or a person appointed by a court, and when, to the extent that the parent agrees that the minor and the health care provider may have a confidential relationship. So let's highlight 3 key points about HIPAA. First, HIPAA creates procedures for obtaining authority to disclose medical records. HIPAA is not a mechanism to compel or disallow the production of medical or mental health records. Second, HIPAA requirements for disclosing patient information in the records are imposed on the health care provider, not on the person attempting to obtain the records. Right? And the third key point is HIPAA's preemption provision. HIPAA basically provides a floor for the privacy and disclosure of mental health records. Now, states may also have their own privacy provisions, and Texas certainly does. When HIPAA's privacy provisions conflict with the provisions of the state's privacy, the ones that take precedence are those that give greater protection to the patient's privacy, that allow the patients broader rights to access their own health information, or that further restrict third-party access to those records. So the theme is the regulations are there for patient privacy and to make sure that only records that are necessary to be released are those that will be released. If a state's laws are silent on a particular matter that HIPAA addresses, HIPAA's provision on the matter prevails. Now, when you look at the state laws and HIPAA, and you see that there's some overlap, some don't, if you're ever in a position of dealing with HIPAA records, it's important that you probably get some legal advice about what you can and can't release with regard to those records. Now, there are three critical rules or aspects of HIPAA. They say it's nice to think in three, so that's what we've got here. The first and the most important for our discussion is the privacy rule. Privacy rule establishes standards for the protection of certain health information. It details certain patient rights of access and the ability of the patient to direct how their health information may be used or disclosed. Privacy rule also establishes guidance on how healthcare providers who perform certain electronic transactions, such as the billing for services, must protect patient information. The second rule is a security rule, and that basically establishes protections for the protected health information that is stored in electronic form. Basically, the mental health provider, the private mental health provider, is required by HIPAA to establish that they are actually protecting these records, particularly since most of the time now they're in electronic form. How secure are those records? The third rule is a simplification rules for transactions and code sets. These provide efficiency for effectiveness of the healthcare system. For example, when a provider sends information to an insurance plan for your treatment, for example, instead of saying this person is depressed and this has been the problem because of depression, they will have the provider use an ICD-10 code or a DSM-5 code, mild depression or anxiety disorder or adjustment disorder and so forth. And that makes things more efficient. And we'll see how that becomes an issue later on. Okay, let's focus on some HIPAA definitions here. These all interact with each other. The privacy rule applies to healthcare providers, okay? Next, the covered entity. Covered entity is a key definition here. Privacy rule applies only to covered entities. It's defined to include healthcare providers who transmit or hire others to transmit patients' identifiable health information, including billings for services in electronic form. Texas definition of covered entity goes beyond HIPAA's. It's much more restrictive and basically makes anyone who holds protected health information in the same category as a mental health professional who had it in the first place. This has raised a lot of issues in continuing education for lawyers and so forth. When they get records, am I in the same position? Yes, in Texas, you are. What is identifiable health information? Another key concept. It's health information that that identifies information related to past, present, or future mental or physical condition, healthcare services or treatment provided to the patient, and payment for the provision of healthcare to the patient. What about protected health information? Protected health information is identifiable individual health information. And all these categories there are categories that can identify what the individual health information, how that attaches to a particular person. And protected health information becomes that when a covered entity then is able to transact information to an insurance plan or likewise. Okay, let's skip now to disclosing protected health information, consent versus authorization. This is key. Mental health professionals basically see these terms as synonymous. Usually when you go into a doctor's office or a mental health professional's office, you're given a statement and basically giving consent or consent to release and so forth. HIPAA is a much broader idea of consent. Authorization is very specific, right? Consent basically HIPAA says that the professional can carry out treatment, payment, or healthcare operations that are in the normal activities of psychotherapy, and the mental health professional can consult with other mental health professionals about your condition. Right? But if there's going to be a release of information, then authorization is required. Authorization, there are core elements here. First, a description of the information to be used or disclosed that identifies the information in a specific and meaningful fashion. The name of the person authorized to make the requested use or disclosure. The person to whom the disclosure may be made. A description of each purpose of the requested use of disclosure. And here you see a little bit of the melding with what Montgomery was talking about with FERPA, is that you just can't release everything. You have to be pretty specific in terms of what you're releasing and the purposes of what you're releasing. An expiration date or event that relates to the individual purpose or the use of disclosure, the signature of the patient and date, and the authorization must indicate the patient's right to revoke the authorization in writing. And finally, when disclosing protected health information for any purpose other than treatment, a covered entity must make reasonable efforts to limit protected health information to the minimum necessary to accomplish the intended purpose of the use, disclosure, or request. Now that's a quick overview of HIPAA, and we're going to try to put these concepts together in the second part of our program after lunch when we get into the scenarios and work with you in terms of looking at which set of regulations applies to which kinds of situations.